to afford him and Miss Wynn some additional time to review red line edits and to get me red line edits on one of the other orders.
Okay.
And so after the continuance motion is heard, if the court has time, we'd like to just try to go ahead and set that. So I know you've got a busy schedule, so if we can maybe get some available dates, we can work that out.
All right. That'll be fine.
Thank you, Judge. Do you want me to proceed on the motion for continuance then?
Proceed.
Okay. Your Honor, we're just needing essentially clarification on the mediation issue. When I reviewed the transcript from the May 10th hearing, which was the enforcement hearing, it appeared that there wasn't anything in the ruling portion that talked about the deadline to mediate, but my notes and the notes of Mr. Morris reflected that you had told us during the hearing you wanted the parties to mediate within 30 days. But then after we completed the bifurcated trial on May 13th, I had asked if you wanted us to mediate within 30 days. And then I and Ms. Wynn created some confusion because we had forgot that you had already ordered Judge Harger to be the mediator in this case. I had asked you if we couldn't get an agreement on a mediator, would we just submit names to you? And you had responded that you wanted to have the mediator appointed by the end of, well, the middle of June would be a good time frame to have a mediator appointed. And so I just don't want to have a situation occur. I had asked Mr. Jenkins and Ms. Wynn if we could push mediation out till the end of July, and they were not in agreement on that. And based on your ruling, it seems like there's a little bit of ambiguity as to when you wanted it to occur. And so I felt like the best person to come talk to would be the source and ascertain what you would like to do with respect to mediation. Mr. Morris, on the record on May 13th, had agreed, and we stipulated we would have the books turned over to Frontier Bank by June 20th in the condition that the bank wanted, and that's set to occur. We were hoping to have a business valuation completed, but they can't complete or begin the business valuation until they have those books, which should be on June 20th. It literally will be on June 20th. And so once those are turned over, we expect that the business valuation should be completed by mid to end of July. And so we would like to ask, did we lose the judge?
It looks like it.
He got tired of listening to me. I don't blame him. We're not on the record at this point, right?
No, ma'am.
Okay.
Let me see. I wonder if he'll call me or if he'll just jump back in. I think I'll give him a quick call.
Okay.
Going to be just a couple of minutes. He said that he lost his internet. He's going to switch over to a different internet, and then he'd be back with us.
Okay. Thank you. Miss Jennifer, how do we pronounce your new last name?
Well, it's Reeves. It looks like Rives, but it's Reeves.
That's what I wanted to make sure, so I didn't say it incorrectly. Congratulations.
Thank you so much.
Yeah.
Still all kind of very new.
Yeah, that's exciting.
It is. Thank you.
What's the weather up there?
It's hotter than
Oh,
you
no.
know it. It's so humid. It's so humid. It was so pretty for so long, you know, it was cool, and now it's just 95 degrees and blazing heat. And
Oh gosh. Oh man. That's hard when you step outside and you just feel like a sauna, like it's sucking the moisture out of your body.
yeah, I mean, it's hard. And I go down to his shop, which he's in an airplane hangar in um uh by Jacksonville.
Oh, okay.
And, but there's no AC, which it's been fine so far. But a couple of days last week, I said, nope, I'm staying home. It's just too hot. And then I've gotten so old now that heat just makes me feel sick.
No, that's not an age thing.
Remember, I know my mom used to say, oh, the heat, it's the heat. And I'm like, I don't know what she's talking about. And now it's like, oh, I know what she's talking about.
Yeah. It's always been, well, whenever I'm out in the humidity, I don't ever eat, which is probably a good diet. Maybe I should come visit because I don't ever want to eat. I'm always hot and miserable.
Well, I haven't quite figured out my new schedule yet, and I have done no exercising at all. So I've got to figure something out.
I don't have an excuse. I just am tired.
I'm tired. That's what it is. I think I'm just like, no, I think I'm just going to sit here.
Yeah, exactly.
I take my 13-year-old dog for a walk and I think, oh, I'm going to get some exercise. But he is like so slow. I'm like, this is no exercise.
It's not working. No.
It's just not working.
I tried to walk the baby with my son yesterday, and I made it over to my parents' house, and I was like, can I come sit in your air conditioning? Because I give up. It's too hot.
So hot. It's just so hot. It's not fun, but
I agree.
hopefully I'll get to the point to where I'm like, okay, enough is enough.
Yeah. Well, you'll get acclimated maybe a little bit too.
I hope so. I hope so. It's fun though.
Good.
Well, it's taken him a little longer than I thought. He did say that he was going to switch internets.
I think he has a hot spot that he's used in the past when his landline went down.
Okay. Guess we could always put him on speakerphone on my cell phone and let his voice come through my end. I don't know.
I'm not adverse to that. I have no problem with that if that's what we need to do.
We'll see what he says.
What are y'all doing?
Becky,
What?
we can hear you.
I know. I said, what are y'all doing?
We're waiting for Judge Langley to.
No, I'm not saying that. I'm saying, what is all the?
That's from a movie that's not before our time. Yeah, Pulp Fiction. You never saw John Travolta dance in Pulp Fiction when he took the mafia's boss's wife to dinner at the hamburger
Mia.
place.
Mia.
That's right. You don't know that, Becky?
No.
If this doesn't look like John Travolta in that movie, then you've just lost your mind. Right? I think I nailed it.
So you were asking what
Did you do this, Will? I missed it. I was looking down.
You
Yeah,
did.
you
I don't
didn't
know
see
why,
the-
but
We were given the piece.
and then the piece got turned sideways, and then it was the
Got
cat. I don't know. It's been a long Monday,
It has.
It has been.
but it was interesting for Becky to go, what are you doing? You know you're on YouTube, right? Yeah.
Oh yeah, I forget.
What are you doing?
We're live. I didn't know. I
Yeah,
forget.
this would be one of those ones to go delete right away.
What are you doing? What are you doing?
What are you doing? You're like, no, but what are you doing? I know what's going on, but I don't know what you're doing.
Yeah.
Becky, we can hear you. I know. What are you doing? That's what she said.
I thought that she unmuted herself accidentally.
I did three.
No,
Nope.
no, I meant
It was on
to.
purpose.
She's calling y'all out on your ridiculousness.
Yeah,
Where's your face though? How come we can't see your face?
because I
You
didn't
join the
put
video.
my face on. Yeah.
You should join with video. It's always fun.
I don't-
I mean, if we're exposed to it, shouldn't you have to be put through the process?
Yep. I think so. Well, it doesn't seem that Zoom is going to be going on much longer in all of our cases. I mean, CPS is we've kind of been holding out for that, but now we're going to go back to live hearings on. Oh, there he is. Everybody straighten up.
Okay.
You're on mute, Judge. There we go.
Sorry for the interruption.
That's okay.
Go ahead, Ms. McClyman. You probably kept talking for a while and I didn't hear it.
I did. I apologize. I didn't realize that you had froze. So we're asking for the court to clarify essentially whether you intended for the parties to mediate within 30 days of that May 10th hearing, which would have made a June 9th deadline. Our original deadline to mediate under the temporary orders from February 4th was May 30th. But based on what the ruling portion from the March 13th hearing indicated, it seemed as if you wanted us just to agree to a mediator by the middle of June. And at that point, Ms. Nguyen and I had forgot that there was an agreed order to mediate with retired Judge Gary Harger. Ms. Nguyen and Mr. Jenkins have confirmed there's still an agreement to use Judge Harger. We had tentatively agreed to some dates at the end of June. I had requested to extend that to the latter part of July, and Mr. Jenkins and Ms. Nguyen couldn't agree to that. And that's kind of what precipitated me or caused me to file this motion to get clarification from you as to what your expectations are. I just don't want to put Mr. Nixon in a position where we're not complying with the court's order or the court's expectations with respect to mediation. For argument's sake, it's been brought to my attention from Ms. Nguyen and Mr. Jenkins that they do anticipate appealing the order on the bifurcated trial. And so from their conversation, it sounded as if they plan on appealing it while this case is still pending and attempting an interlocutory appeal. I don't know if, and I've been researching that issue, if it's going to be right for that type of appeal, but if they do appeal it while this case is open, I would suspect that we would need to get a ruling from the Court of Appeals before we start trying to mediate all the issues as to whether they're going to remand that back down or if they're going to affirm your ruling. And I don't know if you heard my commentary on this, so I might be repeating myself, but we have retained a business valuator. He's going to start reviewing the books on June 20th to create a valuation for Nixon Engineering because it is such a valuable asset. We wanted to have that valued so that we can have a substantive number to discuss at mediation and have that expert on call during mediation to talk to both sides. And then additionally, we are trying to get some of the properties appraised. We have an agreement to use Mr. Lehrman to appraise the downtown Bastrop properties, and we had an agreement to have Deborah Jones appraise the homestead. But we need money to pay for that. And under the temporary orders, money for appraisals was to come from the sale of the properties. And Port Aransas has been listed. Both condos have been listed for sale. I think they hit MLS actually today. There were some things that needed to be taken care of that the realtor had requested to be done before they were active listings. And so we'd like to use the money from those, obviously, to pay for appraisers. And so we would need to get appraisals in before we mediate. And so I just wanted the court to have that information available before it makes a decision regarding when mediation should occur.
Well, my first question is, has Ms. Nixon been given access to the QuickBooks yet?
We have sent I sent a letter immediately giving her information on how to access that. We have asked for them to confirm whether she has, but we have not heard that she is not able to. But we've sent several letters providing information and asking for confirmation.
Okay, Mr. Jenkins.
And Judge, I believe the IT guy, there was some phone calls and emails this morning. Jonathan Adams has not been paid by Mr. Nixon. And so I believe that he had, am I misspeaking, Ms. McClyman, removed everyone's access to QuickBooks but now turned it back on for non-payment?
He had been providing it up until I think Saturday. He turned it off between Saturday and this morning, and he's already made it back. I sent him an email, turned it right back on. So it's back on. Okay.
Oh, so as far as that goes, then Judge, we should be good on that issue. As far as let me address a few things first. There's no written response to this motion because I didn't really know what to do with it. It's unopposed. We agree that the court had originally said mediate by May 30th. That didn't happen because of the bifurcated trial. At the hearing that began on the 10th or the 13th, there's two different, one was the enforcement, one was the additional temporary orders. There was you ordered it, as Ms. McClyman correctly stated in her motion, that the mediator be approved or agreed to by mid-June. We're at June 14th. That's been done. The only other thing that I could glean from the orders was no final hearing date would be given until mediation was complete. And those three things, I think all sides agreed to, have been ruled on by the court. Now, the transcripts were just the ruling, not the 4 days worth of everyone speaking. And Ms. McClyman, maybe correctly, I don't recall, thinks that there was some requirement to mediate in 30 days, and that drop dead day being June 9th, which we've passed. I don't recall that. I don't certainly see that in your ruling. We're ready to mediate. We wanted to mediate by May 30th. that didn't happen. We want to mediate sooner rather than later. This business valuation was neither agreed to nor ordered. That is not what's needed. What is needed is the books need to be complete. Once the books are complete, then a broker should be hired. Those things have been ordered and or agreed to or ordered in court orders. The business valuation has not. We view it as another dilatory tactic to just not let anything get done. Ms. Nixon is anxious, ready, and willing to mediate. I have Judge Harder's schedule from his website, and if the court wants to clarify, that's fine. If the court wants to give us a date by which mediation must be complete, that's fine. I'm happy for that. My client wants this done sooner rather than later. We're 8 months down the road from the ex parte TRO putting Mr. Nixon in charge of the business, and there's been lots of excuses for the books. We got it. I think everything's going to be done by June 20th. And we don't want this formal business valuation, which has not been ordered, not been agreed to further be another obstacle in the road to mediation. We're ready. We have dates, and we'd like to either the court to pick some or let me run them by everyone's schedule and see if we can't get mediation set up.
May I briefly respond? I just want to remind the court there was a court-ordered custody evaluation. Mr. Nixon has started his sessions with Dr. Thorne, who is the court-appointed custody evaluator. He's completed, I think, 2 sessions at this point. Dr. Thorne had asked for information for collateral witnesses, and we're collecting that to give to Dr. Thorne. I anticipate having some of that information over to him this week. I don't know if Ms. Nixon has started her portion of the custody evaluation, but I anticipate that that's not going to just happen overnight. And then with respect to the business valuation, I mean, that's our expert. I don't dispute that. We're allowed to hire whatever expert we would like. We are required to turn over the books to a business broker once they're completed, and that will happen. We'll comply with that. But the business broker as well will need time to review the books from June 20th to assign a value to the business for sale purposes. So I don't think that's any different than the type of work that the business valuators, I think it's interchangeable, whether it's the broker or the valuator. I'm still asking for additional time. I don't think that mediation happening in the next week is plausible when we don't have a custody evaluation done, and we won't even have an EBITDA from the broker regarding the value of the business.
Judge, I'm not asking for it to happen in the next week. I don't think everyone's schedule will allow that. Has Dr. Thorne been paid, Ms. McClyman?
Yes, I asked my client to borrow $10,000 from his parents to pay it.
Okay, so he has been paid for both sides?
He paid his portion to start. I would assume it's applied to both. I mean, we can reconcile that payment. The parties were ordered to share in the expense, but right now I wanted the process to start. So he borrowed money to pay the retainer for Dr. Thorne. I don't think it's divided between any party at this point. I think it applies to the work he's doing for the whole case.
Yeah, I'm not sure that we were aware of that. Ms. Wynn's not here. I don't think I was, neither here nor there. Again, Judge, we're not wanting to mediate in the next week, but the May 30th deadline that we went past for whatever reason, certainly had to anticipate child custody evaluations. I don't know that one thing is dependent upon the other. We can still go to mediation. And if the parties can't mediate their differences, that child custody evaluation will help the court in making its ruling. I don't see why. It just always seems to be something that delays mediation, and we're ready to go. We're ready to comply with the spirit of either the agreements or the court's ruling, and that was this case should have been mediated 2 weeks ago.
Mr. Jenkins, are actions being taken to appeal the court's ruling from the bifurcation?
No, sir. I asked Ms. Wynn about that earlier, and was told that from her understanding that couldn't be done until no appeal on that order could take place until final orders are entered.
Okay. I couldn't read that sheet. What dates does Judge Harder have available in beginning after the 4th of July?
Would you like me to read them out loud, Judge?
That might be helpful.
July 5, 6, 7, 9, 12, 14, 22, 23, 26, 27, and 28.
Why couldn't you go ahead and have at least your initial mediation occur beginning on the 5th, and then allow the mediator to reschedule if it's necessary?
So I'm on vacation on the 5th since that's our holiday. Our office is actually closed on that day. And so I have
Okay.
I mean, if the court's ordering us to go,
What is the next date that would be reasonable after your vacation?
I mean, I'm seeing if I'm in court on July 6th. I'm not in court on July 6th.
Okay. You want to do it on the 6th then? And then the mediator at that point in time will have the authority to reschedule to whenever the mediator thinks is best.
Judge, I've sent a quick message to Miss Wynn's office to see if she could. I hate doing this and holding you up, but that date works for me.
Well, that's okay. I'm sitting here drinking coffee.
2:30 in the afternoon.
Absolutely. And if it goes much longer, I may add something to it.
I've got bubbles up on that July the 6th date. Yes, sir. We're good for the July the 6th date.
Okay. Do you need to contact your client about his availability as McClyman?
I think that he will make himself available.
Okay. Well, then July 6th it is.
And that's subject to Judge Harger. If we tell Judge Harger concerns about mediation being successful, is he allowed to then reschedule it?
I like giving the mediator a lot of discretion to resolve those kind of conflicts in order to find a solution, particularly in a case that involves all the issues that y'all have.
Understood.
Judge, does Ms. McClyman need to check with Mr. Morris? We've run into that problem with mediation before too.
I've already checked his schedule and he's clear on the 6th.
Looks like everybody's available. Okay.
All right, Judge, I'm going to ask Stacy from my office to go in and get on the computer and sign us up with Judge Harder's online website for the 6th. Is that all right?
Whatever you got to do.
Okay, that's all I have, Judge. Thank you.
Can we please have a date and schedule it for the entry of these orders? I know that your schedule is busy, and since everybody's here, it would be helpful if we could schedule that.
Good idea.
Well, I know that I'm going to be in Bastrop on the 6th of July, but y'all are going to be in mediation now, so you can't do that. how quickly will you be ready to get the order to me for entry?
I had it to them last Monday, and so I would like to think that if we could maybe get it entered next week, that would be helpful.
Miss Wynn Miss Wynn drafted the orders, Judge, on the 1st, sent them to Miss McClyman on the 6th. 2 days later, she filed the motion to enter. She was at mediation on that Tuesday in between the day that she got them and the day that the motion got filed. We just need adequate time to, there's no rush. There's no emergency. We need adequate time to look at them and get a response back.
So I got them on June 1st. I sent her the edits on June 7th. And so I haven't heard anything back. It's the 14th. I would like to see if we can't have a hearing on the week of the 21st or the week of the 28th.
Well, that's not true. Now, we spoke on the phone on Friday and you told me that you would give us more time to look. And so we didn't. It's not that you didn't hear anything till today. That's not the fact of the matter at all.
No, I don't disagree that I gave it to you guys on Monday. And if she needs, I had 6 days. If she needs 6 days or more, that's fine. Today's the 14th. She's had a week. I would like to give her another week. And then I would like to have a hearing next week or the next. That would have been 14 to 21 days that she would have had.
2 weeks is fine, Judge.
And the earliest that I have available is June the 30th. No, I don't have that one available. It's July 1st or the 2nd, either one.
I'm available on both days.
Me too, Judge.
We could do the afternoon. Are we going to do this by Zoom or is this going to be in person?
It'll probably get worked out, but let's go ahead and get it set.
You want to do it for the afternoon of Thursday or the morning of Friday?
What's the court's availability?
We're available, right, Haley? We're available on the afternoon of the Thursday. I'm sorry, I lost my calendar, but the afternoon of the, did we say July 1st or July 2nd?
July 1st.
We could do the afternoon of July 1st at 1:30 or anytime the 2nd, preferably morning.
1:30 on the 1st then.
I prefer the 2nd. I have an ALR hearing on the 1st at 1 o'clock.
Okay, what time do you have on the 2nd then, Jennifer?
Oh, we're open. So it could be that morning.
I would prefer the morning.
Okay, well, let's do it at 10 o'clock on the 2nd then.
By Zoom or person?
Yeah, as long as you've got the submission to me that I can review before then, we can do it by Zoom.
July 2nd at 10
Okay.
a.m.
July 2nd at 10 a.m.
Okay. Yes, sir.
Okay,
Yes, sir.
how's that work for you, Haley?
That
Hey,
works for me.
Okay,
I'll pencil you in.
all right.
Keyword.
What else can we get done today?
That's all we need, Judge.
That's it.
Well, y'all are really easy today.
Monday. Mondays are easy. We'll go get some
All right,
coffee.
we'll see you on the 2nd then.
Thank you,
Okay.
Judge.
Thank you, Judge.
Thank you. Bye-bye.
Bye.
Bye-bye. Y'all have a good afternoon.
Bye.
You too.